everyone. Stephen Byrne, I've been invited here by you folks to do some of the training you're now required to do by the under state law, so you can keep your positions. We don't quite know what the penalties are yet if for some reason you don't get your training done. We're not sure. We don't want to find out. But I did, we're doing this, I'm an attorney in Farmington, been doing land use for 30 odd years. Started working with my father, who also was a land use attorney. He did it since the 70s. He kind of brought zoning to a lot of towns. And then my oldest daughter, I'm going to see if she maybe wants to get involved in this line of work, so you can encourage her to, of course, how wonderful it is and exciting and knowledgeable. Because I know you guys have had a little bit of a tough time, I think. I don't know how much we'll do on affordable housing tonight. You might have had your fill of fair share and all that stuff. You probably know more than I do about that. So I did pass out the land use training guidelines, so that's what we're trying to fulfill. We need 4 hours of land use training this year, and then after that it's 2 hours per year. Yeah, it says on or after January 1st of this year, each member of a municipal planning commission, zoning commission, combined P&Z, or zoning board of appeals shall complete at least 4 hours of training. So the state statute, which is now 8-4C, there's on page 2 and 3, there's like 4 areas we're supposed to cover in those 4 hours, and one that's mandatory is 1 hour on affordable and fair housing policies. And then the other 3 hours can cover, the legal basis for, your planning and zoning commission and zoning board of appeals, where your authority comes from. Also, how to run a public meeting, how to conduct a meeting, how to review an application, reading a site plan. So basically what the state law says, 1 hour you have to have on affordable housing and fair share housing. The other 3 hours is the typical workshop stuff, which,
Do you have
Yes.
extra copies?
which one do you need to,
The one you're going over?
it says land use training guidelines, and you have it. Anybody else need, I think, one more, Nikki. Now, on page 5, it does say, and this was made by the Office of Policy and Management, which was the Office of State of Connecticut. So they're supposed to be running, kind of keeping track of you guys getting the education you're required to get. And it says, on page 5, they do say, since there's no formal state certification program, each municipality is ultimately responsible for ensuring the compliance of its commissions and board members with this state statute. So what we do as the Connecticut Federation of Planning and Zoning, we know who's here, and we'll make a certificate, and we'll send it to Chris, and then the town of Woodbridge will keep track of your, that you've completed your training, and I guess you make a report to OPM at some point, and that's it. So your job is, you're here, and you get credit for being here, and then we'll make the training certificate, and we'll give it to Chris, and you'll be all set. And it's kind of an informal process. I know the University of Connecticut is trying to kind of like centralize the training program, if you will. But OPM for now is keeping it very much an informal education process. So, the way I read it, you don't really even need to have an attorney here. You could have, a planning consultant maybe come in and talk to you about affordable housing ideas and that kind of thing. I always wonder sometimes, could you count, if you're working on your affordable housing plan at a meeting, could that also count as training? If you have a professional come in, a planning consultant or someone walk you through how to do that plan and how to implement one for your town, if you could somehow get credit for that. As I always said, a lot of times you get educated when any application comes in. If it's a special permit application, it's an application for a variance, usually someone will run through, staff will run through how you're supposed to handle that application, what standards you have to apply. So right now, it's pretty flexible, the training requirements, so you should look for any and all opportunities to count towards this requirement. It doesn't have to be someone from UConn, it doesn't have to be someone from your COG, it doesn't have to be from the Federation, so. I always wonder if even, staff could do some training as well, just walk you through your regulations, especially for new members, just walk through the different sections, that kind of thing. So that being said, to start your training, these workshops, we usually spend quite a bit of time, it's the purple book, it's Workshop Materials on Good Governance. And on the front page, there's just 4 items in here. There's, guidelines for conduct of public meetings and public hearings. There's a little section on conflict of interest, a little bit on the FOI, and then there's also some federal limitations on your authority. And then the last section, which is labeled number 4 again. How'd that happen? Rules on making and amending motions. So, but I have found in these workshops, people do like to spend a little bit of time on really the first 2, which is just guidelines for conduct of public meetings and public hearings, as well as conflict of interest. So, if you have any questions or want to stop me, that's fine too. If something pops in, as I'm going over something, if you have a question, need a clarification, just let me know. On page 1, we cover guidelines for conducting public meetings and public hearings, and those rules are found in the Freedom of Information Act, which is Connecticut General Statute, Section 1-200, and a sequential, this parts that come after it. In number 2 there, public business should never be discussed between or among members of your commission or board outside of your public meeting or public hearing. Those are for pending applications. So that would include, if the meeting or hearing, if it's continued, you don't decide that application that night and meeting adjourns, and you're out in the parking lot, you really shouldn't be talking business anymore. A few commissions I work for, a lot of times they'll go out after a meeting, to have a drink or something. Again, try not to talk shop, because everything you do should happen in a public forum.
Quick question.
Yep.
So I'm on the ZBA.
Right.
And often we'll get an appeal application.
Mm-hmm.
Before the meeting, I'll go to that property and often talk with the owner just to get a better sense of what it is that they're asking for. So that's not a conflict?
As a chairman, you're the chair.
Yeah, as a chairman, but also as a board member.
Well, the application's in, so we'll get to that later, but like site visits and things like that, you can go individually.
Yeah, right.
Right.
Individually, but the homeowner, I don't want to just show up.
Right.
Because especially these days, you get shot.
I know.
So I'll go and, introduce myself and talk to the homeowner and ask them about their application.
Mm-hmm.
But just by myself, not with any other board member.
You have to be careful with talking, too much like that with the site visit, and we'll get to that, because, again, if you're talking with, the applicant just one-on-one, if there's, suppose the neighbor is not in favor of the application, and they see one or more members going one-on-one talking, they might feel, is there something going on? Are you getting too friendly with that applicant? Or now you're going to be too favorable of that applicant? So that's all we'll get that with conflict of interest too, where you want to keep up the appearance of fairness and that sort of thing. So if you do a site visit, you can interact with the property owner, but you should keep it to a minimum, very much like you said, well, say it's a variance, well, where are you going to put the building? Where's your property line? Just basic what don't get into the merits of it. That's what I'm trying to say. So site visits, fact-finding, you really shouldn't get into the argument of it, like what the hardship, that sort of thing is.
Yes, what I'm usually is to show me, I have the drawing, but,
Yeah.
can show me the land, because like the topography, it's
Right.
sometimes hard to, you can read the thing, it says it goes down by X number of feet, but
Yeah.
seeing it
Yes,
often gives you
you
a
understand it
different
much
picture.
better, right. So just be wary, not to get too much into if he's trying to explain the hardship and that sort of thing.
Just
Don't
one
go
more.
there,
Okay.
Oh, yeah, they're right there, site visits, yeah, number 3, site visits. Yeah, that's the special difficulty, is you're just worried that, perception, it's all about perception, as you know. We're supposed to provide a fair hearing, and if the neighbor is against the application, against the variance, and they see one or more board members stopping by and talking to the guy, they might feel that there's favoritism or something. Of course, what you do then is a site visit. It's hard to take minutes, that sort of thing, or it's not a meeting. Anyway, at your hearing, if you did go to the site, make that part of the record. Do as part of, during the hearing too, don't wait till the hearing's closed and then talk about it afterwards, because if it goes to court, the judge will only, the record is only the testimony and evidence that comes in during the hearing. Once that hearing is closed, it's like it never happened. So I've had that happen before, where the members don't really speak their mind during the hearing. They feel they're just there to receive information. Then they close the hearing. Then there's a wonderful discussion, what they all know personally, what they all know about it. And none of that will count as evidence to support your decision.
So, excuse me, so
Yes.
if multiple individuals go on a site visit, we should be documenting that during the meeting that we went?
Just what you saw. If you have anything, you should say you went there. Yeah, I was there. I did see the property. It adds to your, again, if a judge is looking at the record and then, why did you vote a certain way? Now the judge says, oh, I see the board member, she was there, and she, she's familiar with the property. She knows everything's going and that sort of thing. So just stay for the record. You can go as a group, but then that makes it a meeting. So that means you'd have to notice it, and then the public can come on and follow you on. And a lot of property owners don't want the liability, so they clear it with the property owner. That's often discouraged anyway, because it's hard to have a meeting out in the field. Nobody can hear, if it's a windy day. It's hard to make a record. You can't, take minutes accurately because it's a little more chaotic. So that's why staff will often encourage you, go alone, check it out. And that's what this little booklet says too at the very bottom of number 3, paragraph 3 on page 2. Having members visit or walk a property individually, it avoids the public meeting problem and is recommended. So if you go alone, there's no FOI concerns, which is nice. Now, conflict of interest, bias, and predetermination. And of course, if that issue ever comes up, it's supposed to be raised at the, when you're going to start to, when you're discussing application or it's a public hearing is open on the application, it's supposed to be raised before you, where you're challenged by maybe the applicant thinks someone maybe is biased against them, or like I said, a neighbor comes up and says, no, I think you need to recuse yourself because you're close friends with the applicant, something like that. So it's not an actual conflict of interest, it's a perceived conflict of interest, because we're all about how things look to the public. It's supposed to be a fair hearing. So even though in your heart you know that, no, I can render a fair and honest decision on this thing, if the person is a friend, if you've done business in the past, that kind of thing. It's like, if your vote isn't needed, the safest course of action is to recuse yourself. And you can state on the record, I don't have a conflict, however, just to preserve the appearance of fairness, I'm going to step aside and let an alternate take my spot.
Couldn't the applicant then say, if we're trying to do this fair, and say, well, it wasn't fair because no one actually saw the actual property?
Oh, they can't go there. It's got to be more of a personal. They can't.
No, but I'm just saying, if we're worried about perception and that we don't go, then the property owner could argue that it's not as fair as it could be and objective because you didn't actually, all you have is a piece of paper and a drawing.
There's no requirement you do a site visit, so you just get informed. And if if one member goes, they can convey that knowledge to the other board members or commission members what they saw and then explain the map better. So yeah, we don't get into that depth of. You don't have to do a site visit. You do have to be familiar with the documents that are submitted. You should try to read everything. You should be familiar with your zoning regulations, of course. And also, if it's a public hearing and you miss, it's a multi-night public hearing, it's over 3 nights, and you miss one of those nights, you can still vote on it if you listen to the recording of that hearing that you missed. And someone should take note of that, so that you did actually go in and listen. And then you just state that on the record, that yes, I wasn't here last Wednesday night for the hearing, but I did go to the land use office and listen to the recording of that hearing. Number 2 on page 2, always remember this: members of your board or commission should not publicly state a position on a matter to be considered by the agency until the matter is reviewed and decided. So you're like a jury in that regard. A jury, and if a trial, they can't say a word, but once the verdict is issued, then they can go write a book, and go on The View and go wherever they want to go and say, you guys the same way. Yes?
All right, so when you say a matter, do you mean an application, or do you mean a position that you would take, say, maybe you want to establish an industrial park or a group of condominiums? Do you have to keep all your opinions to yourself? Is that what you're suggesting?
No,
or
just
an application.
A particular application.
So a matter would be an application.
So you can run for office and say, I'm running for office because I think Woodbridge should not ever have another fast food place in town. That's just your field, ruins a town.
Understood.
And then you're sitting here, McDonald's comes in and says, I want you to sit. It's like, no, that's just my general, but you could convince me that maybe we do need one McDonald's. That's a great
so
spot.
here the word matter means an application.
Yeah, it's a pending application, because there was, I forget what town it was, some commission member ran an election, and he was running to, keep the town rural. And then, he wins on that, and it was actually, there was the zone change application came in to, rezone a rural area to allow for some commercial use. He voted against it, and the guy said, well, you should have recused yourself, because I know you were never going to vote for it because you want to keep your town rural. But the judge says, you're running for an election. I mean, you can't, how are people supposed to vote if they don't know how you stand, how you want the town to develop? Because that's your job, especially planning and zoning, right? It's a planning component. So you're allowed to be labeled as, the anti-development guy or the, the farming guy or whatever. So,
Understood.
but when that application comes in, you just don't get specific. Like, I'm never voting for this, because you're just, an open mind means you don't have an empty mind. We all have opinions and biases and that sort of thing, but you can be persuaded. Page, right to enter private property. This isn't at one time we thought we had the right. Now we know we don't have the right. You must be invited onto the property.
So if somebody files an application,
Mm-hmm.
you can't assume that you can go, you have to speak to the owner. It's all right to go and look at
Right.
the
I don't know if your applications have it. Some will have a little line where the owner signs that by filing this application, you agree to allow commission members on your property and staff, and so. But you're right, applications is not an issue. It's really ZBA for enforcement. Sometimes the guy's like, you're not going to see the violation. I'm going to hide it behind a fence and you don't know it's there. So planning and zoning, it's often not a problem. People want you to come on because they're trying to get you to approve something.
In this town, the Inland Wetlands Agency has that verbiage, right? And it gives, by signing that application, they're giving permission to both staff and the agency members to go on the site at reasonable times and hours.
Right.
You can't go in and do anything super out of the flash.
But we don't have it on the other. We don't have it on ZBA, so
You could.
we should, yeah. I mean, I find it beneficial to go on site to see. To your point, I mean, this doesn't tell me what's going on.
Especially ZBA, if it is like an appeal of a
Yeah.
ZEO decision, they're going to be less cooperative. Everyone else is sort of like, they understand I'm filing this application, I kind of need, we need to let people on. Let's see. Page 3 is a little bit on conduct of meetings and hearings. And then if you have bylaws, you should follow your bylaws. If you follow Robert's Rules of Order, you should follow those Robert's Rules of Order. And then now public comment is number 2. And it says, unless the agency's agenda allows for open public comment, the public has no right to speak at a meeting. That's a big difference between a meeting and a hearing. You can always explain that to people. Say, this is a meeting. You get to watch us. At a hearing, then everyone gets to speak. And that's why sometimes, like with a site plan application or a subdivision, you don't have to hold a public hearing, but as you know, if it's kind of a controversial thing or it's a huge subdivision, something like that, a lot of times, a lot of commissions will hold a public hearing. They don't have to, but for that purpose, so you can hold, have public comment. Because it gets confusing with public comment, is you can sometimes inadvertently turn your meeting into a public hearing and you improperly notice public hearing. So when you do public comment, there should be literally no back and forth. It's just, you're just listening. So people come to bring things to your attention. It should not become, for instance, a lot of times public comment, someone will come in and kind of be turning in their neighbor, say, yeah, he's doing something that's not permitted under zoning. That's not really fair to the accused person. They're not there to respond. So, let the person speak for the 1 minute or the 2 minutes you allow, and then just say, okay, we'll take that under advisement. Thank you for bringing that to our attention. So don't allow your meeting to become a public hearing with public comment. Try to let people know they're there just to make a statement. They could have just as well just written it and sent a letter in. Because otherwise, right, now you've got a public hearing, which was not noticed, it's illegal, and you get an FOI complaint filed against you. Now, in conducting your public hearings, on page 3 there's some little helpful hints how to run a nice public hearing. So, such as, you can try to minimize redundant testimony, but if people want to be redundant, you kind of have to let them be redundant. And speakers must identify themselves. A lot of times people don't want to, but the reason why we need them to identify themselves, we're trying to make a record. We need to know who spoke. We're not trying to track anyone. So that sometimes helps if people are a little bit leery, telling who they are. And then, you guys are not bound by the rules of evidence, so you don't worry about hearsay, whether it's relevant. Just allow people to say their piece if they want to. And things move faster if you don't get into that kind of trying to keep people too focused. Just let people speak, present what they want to present, and you sift through it after. Now, cross-examination, that's part of a fair hearing, the right to cross-examine. The best way, though, is to all questions just direct to the chair. So if it's the applicant and they've got their engineer or whatever, and someone from the public wants to ask the engineer to clarify something or whatever, what you do is direct it to the chair, and then the chair can then usually ask the applicant, who would you like to respond to that? It just keeps it from getting, if it's contentious, you don't get that, the head-to-head stuff, because as you know, it can get kind of heated. This is a nice way for the commission to insert itself between the applicant and any, if there's an adversarial party. And just kind of keeping things, it slows things down a little bit, so then it allows, staff, whatever, to track any documents coming in to help make a better record. Now, letters and correspondence, it's often a question when you have to read in all the letters into the record. If it's a public hearing, you get letters from the neighbors. If you're going to read one in, you should read them all in, because trying to be fair. So if it's, it depends how much time you have. I mean, there's nothing that says you can't read them all in, but you don't have to read them all in.
Do you have to read any?
You don't have to. You can just say I've seen some commissions say we received, 15 letters in favor of the application and 25 against. And then the staff ahead of time, when this comes in, can just note, for the record, what came in, identify those items. So.
Other than it being noted in advance, on the record, do the submissions have to be noted on the record in terms of who submitted the letters or statements for a proper record to be made?
Because you're really doing it for the benefit of the court. Sometimes it's clearly like a form letter. Someone just prints out the same letter and everyone just signs and dates it different. And I've seen commissions just they'll say a packet, 13, letters in favor. If they're individual letters, it's also proper to say from so-and-so, to the commission with a date, so you can kind of identify. Because sometimes you do pull, a commissioner may base their decision on someone's letter, and that way the court can find it later. So The record, it's, again, you're not a court of law, so the court's not looking for perfection, but you do need to track evidence that comes in. So like I said, sometimes if it's a form letter, it's someone just printed out 20 of these things and got people to sign them, you can just staple those together and have it as one. But if it truly is individual letters, I think it's best to identify it properly. Who was it from and the date. Just makes it easier if it goes to court to track it. In expert opinions, you do not have to believe an expert. However, if you're not going to believe the expert, that's during the hearing, you also get to ask questions. A lot of commissioners don't want to ask questions because they don't want to appear to be biased. But, your job is your fact finding. So if a commissioner, if a traffic expert says that, putting in a quarry that's going to have, 50 trucks a day coming and going will pose no significant traffic hazard, you might be thinking, I know that road. That's going to be a problem. You can definitely ask questions of that expert and say, explain your report, and you can disagree on the record and say, I live here and I travel that road every day, and having that kind of traffic is going to be a hazard. And just get on the record, though. So you are allowed to, because, experts, they're getting paid by one side, and they can look at things two different ways.
So it's not sufficient to state those reasons during the work session? Has to be during the
Yeah, during the hearing, during the public hearing, definitely, yeah. Because we used to get when we used to do a lot of the tower cases before the siting council took over the wireless towers, the wireless companies would always bring in a realtor, some appraiser, saying having this 190-foot tower in the center of Woodbridge, that will not negatively affect property values at all. And they'll have their little report. And it was very effective. A lot of commissions I do work with, there often is a realtor on there, and that cross-examination saying, I'm from Woodbridge, I know the property values for having that tower in our town is going to call them out on it. But it's got to be during the hearing, that way it's on the record.
But what about a situation where there's an applicant bringing an application, and there's experts on, say, traffic, and then the engineer, et cetera, the kinds of applications that we see on a regular basis here.
Mm-hmm.
And it's during the entirety of those presentations that I, as a commission member, form an opinion.
Mm-hmm.
And I may hear something that one of their experts says, and there'll be counter traffic study, another counter traffic study, blah, 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 blah. But then it's not until the work session that we actually articulate our opinions, because maybe we haven't actually formed them until we've received all the information and heard all the experts. So I think, to the extent that it's possible, that's not something we need to be concerned about, right? I don't need to be articulating my conclusions about what an expert said when an expert says it, do I?
If you're going to not follow that expert's advice, if two experts come in and they're on both sides, that makes it easier. Then you can take your time and say, well, I agree with expert A versus expert, B. But sometimes you only have the one expert, and that's the one opinion you have. Then yes, it will be important for you to be on the record, raising your questions why you don't agree. If that means keeping the hearing open, so you can do it that way. Because, the classic one is another one I got involved in was with well water, where there's already an issue with wells going dry in the summer, and then the developer comes in and wants to put in 10 more houses, and his expert says that will not affect the groundwater levels at all. And you may want to sit on that, sleep on that, and come back and say, I do not believe you at all. We know there's already a problem up there. How is drawing more water? Just, you can make those common sense arguments from the expert, and just because the court will want to know you did ask those questions. And then it's really fairness to the expert to then give his or her response to counter your concerns or questions. So.
Is that because if the decision of the regulatory body gets challenged in court, as you keep pointing out, right, then the court has a record to look at whether or not we fleshed out? Isn't the standard just that we heard and took in the testimony?
But it's also, it's also fairness too, where you need to give that expert the chance to respond to your questions. So.
But if I don't have questions, I don't have questions. If I'm just hearing
I know, I'm the same way, you gotta digest it and then later on, but that's why you keep the hearing open if there's time. Because I think sometimes you're hearing an expert and saying, that's not, it doesn't
Sure,
feel
sure,
right, you
yeah.
can't really pin it down, because it's a lot coming at you in one night. And, I mean, sometimes an applicant's really nice to get everything in way ahead of time, maybe you could look at stuff ahead of time. But as you know, it comes in that night usually. So, yeah, to keep the hearing open, maybe to allow for, if the expert doesn't show up at the subsequent hearing, at least you gave him a chance. You can say, we're going to keep this open. We'd like to have your expert here to answer some questions. Let's see. Now, once the hearing closes, the rule is no more evidence comes in, but there is an exception to that rule, which is for your own staff and if you hired a consultant of your own. Because technically, your experts are not taking sides. They really are just trying to interpret what came in, evaluate what evidence came in, and tell you whether or not it's satisfying your regulations. So that's one exception. So if it's your own experts, their stuff can come in afterwards. It's better, though, if it comes in during the hearing. But sometimes, as you know, you have statutory deadlines to complete the process, so sometimes you just ran out of time. Now, making decisions, that's on page 4. Of course, there are time deadlines for making your decisions, and you have to strictly adhere to those. With the ZBA, if you miss a deadline, it's the worst that happens is you do it again. You have to do a do-over. But for planning and zoning, for site plan, and for subdivision, the penalty is much worse. It could be it's automatically approved. So that's why for you guys, you don't dare miss those deadlines. So, for a site plan, it's 65 days, start to finish. And don't get caught in a trick. Some of these guys, they'll offer, let's do a public hearing on this site plan, and then they will mislead you. Well, it's a public hearing. You get 65 days to open it, 35 days to hold the hearing, and 65 to decide. That is not true. The site plan is 65 days, period, whether or not there's a public hearing or not. And then whatever decision you make, always make sure you cite to your zoning regulations. That's the standards are in there, the requirements that need to be met. And the court will love that. If you're going to deny it, say, it's because they failed to meet section, whatever. And of course, during your meeting to make a decision, you should openly discuss the merits of the application. Sometimes you might have your attorney do a draft motion, something like that. What you don't want to do in that case is just at your meeting just say we have a draft motion, all in favor, and you just vote on it. It's done, because that's going to go to court possibly, and then the applicant will say they didn't make that decision, their attorney made that decision, and you don't want that to happen. So always have a little discussion, a little round table. Who's in favor? You have that motion to approve. How you feel? And you say, well, doesn't meet this section of the regulations. I'm going to vote against it. Okay. Any questions on that stuff? There is a little bit of advice at the bottom here where it says if your agency, if you guys, encounter something that's difficult, a question you need answered, if there's time, there's nothing wrong with continuing that application so you have time to talk with, get an opinion from your attorney or talk to staff, that kind of thing. So do take full advantage of the time allowed. There's no rush. Now, conflict of interest, I do a little bit on page 5. Let's see. 1, 2, 3, 4. I guess the 5th paragraph down, just what a personal interest is. Personal interest has been defined as an interest in either the subject matter or a relationship with the parties before the zoning authority, which would impair the impartiality expected to characterize each member of that zoning authority. So, of course, personal interest could be favoritism toward one party or hostility to a party, personal bias or prejudice, which imperils, so imperils open-mindedness. So you don't have to have an empty mind, an open mind. And of course, the decision as to whether a particular interest is sufficient to disqualify is necessarily a factual one, and of course depends on the circumstances of each particular case. You should also know that the decision to recuse yourself is the individual commission members alone. So you don't get to vote someone off the island. It's if they choose to stay, get to stay. And what do you do if you do recuse yourself? The best thing is you should leave the room, because sometimes you'll have like an accusation made that even if you are sitting in the room, you know, someone could say, well, they're still giving signals to their commission members how they want you to vote. So the best thing is just to leave. And again, I think I mentioned this before, is it's not an actual conflict, it's just the appearance. So it's almost like the realm of conspiracy sometimes you feel. But the best course of action is, you know, it's always best to just recuse yourself. You have to be careful. Sometimes, you know, you can't allow the whole board or commission to be disqualified. You still need to take care of business. So, you know, a lot of times it's one member, and if you have enough people there for a quorum, that person gets set aside. But sometimes, especially ZBA, you kind of want to have the four there. You know, if someone's just out, and then, yeah. So you might have to stand your ground, because you have to take care of business, so. Now, on page 6, we do little highlights of the FOI. You know, what's a meeting? Of course, it is a quorum. Of course, what's the one thing you can do without a quorum? Is you can continue a meeting due to a snowstorm or other inclement weather, that kind of thing. So if two of you can get here, one can make a motion to continue, one can second, and it's a done deal. So that's more for public hearings, because you don't want to run the notices again or something, that kind of thing. So that's just a little fun fact. Otherwise, you need a quorum. Now, the FOI recognizes several types of public meetings. There's your regular meeting, special meeting, and an emergency meeting. And there's pretty much never a reason for you guys to have an emergency meeting. Nothing you do really can't wait, you know, to do a special meeting.
Could the meeting then be changed? So, as your example of a snowstorm,
Yep.
it comes up, no one knows what's going to happen.
Right.
Could at the last minute switch to a Zoom meeting? And
That's a little bit, you get the insert. Problem with the Zoom meeting, you're supposed to give 48 hours notice that you're going to do a Zoom.
okay.
So that's kind of kills that idea.
No, it's just weird. But
Yeah.
everybody's contacted, including the applicant plus the
Right, get everyone to, right,
board
exactly, set it
members.
up.
We can set it up.
Mhm. But with the FOI, they're always worried about the public, how would the public find out adequately, so you can't save it.
Okay.
But it's 48 hours, so if you're watching the weather and it looks like something's rolling in, maybe you could convert something over.
I'm
You
just
know?
curious.
Yeah. But that's why this is supposed to go with the purple book. It's a remote and hybrid public meeting requirements, which are now good forever. They were supposed to terminate at some point, but now they're section 1-225A. And thing with remote and hybrid, like with a regular meeting or even a special meeting, you know, you're supposed to post the agenda 24 hours ahead of time. If it's going to be remote, it's 48 hours. What a lot of commissions do is they just post everything 48 hours now ahead of time, because a lot of towns do like the hybrid thing, so they just do the one notice that way instead of having to post a 24-hour and a 48. Just do the 48-hour notice.
Well, could you then make every single meeting hybrid?
Yeah, if you got the equipment.
Well, that's what I'm saying.
Yeah,
So-
you could.
So if the public wants to come to the meeting and
Yep.
it's hybrid,
Right.
and then there's a snowstorm, you can say,
Everyone stay home.
We're good
Zoom
to
in.
go.
Yeah.
okay,
We have to talk to our powers that be about that.
what's that?
We have to talk to our powers that be.
Well, if the
No,
town,
just-
No, I'm saying,
if the town of Morris can do it, everyone can. They have a nice setup.
yeah, well,
Well, you could have spent the COVID money on
There's been
that. But that's the, that is a nice solution. I mean, that gets rid of a lot of worries, doesn't it? You know, about snowstorms and that kind of thing.
Yeah, it's done.
Getting a quorum, you can always track someone down, have them call in. If they're at their birthday party, you could just step away for an hour and jump in. Okay, we covered that. Of course, now executive sessions I cover a little bit on page 7. There's also the paragraph above it. What is not a meeting or considered a meeting under FOI? So non-public meetings under FOI. It says any meeting of a personal search committee for executive level employment candidates. So I guess if you're looking for a new CEO or something, you could go in executive session. Number 2 is interesting though. Any chance meeting or a social meeting neither planned nor intended for the purpose of discussing matters relating to official business. So even I warned you not to do it because I don't want you to ever have an FOI complaint filed against you. If someone does catch you having a chance meeting, you just run into each other at a party or at the grocery store and they hear you talking, the FOI will excuse that. But it's just better not to do that. See, strategy or negotiations with respect to collective bargaining, you guys don't do any of that. Now, a caucus of members of a single political party, I always thought that to be a strange exception where, but yeah, if you're all the members of the same political party, even though you constitute a quorum, that is not a public meeting. So, all the Bull Moose party members could meet and discuss things, and anarchists can all meet together and discuss an application.
Parties.
It's time to get the air.
Right. Let's see. And of course, you can always get together ahead of time. Communications related to setting up when can everyone get together for a meeting, talking about what's on the agenda, that sort of thing. Just that you can do by an email thing or something, just to see when people get together. Now, executive sessions. Again, for you folks, that's going to be pretty much if you get sued. That's your big executive session. For planning and zoning, it can include, sometimes your CEO might bring to your attention, want to be on your agenda because, he or she's thinking of doing an enforcement action. But it's going to be hit on the budget to fund that, so they might want to bring it and discuss with the commission. That you could go. That can be pending litigation. If they're thinking of going forward with enforcement action. So that you can go into if you want to. And with executive session pending litigation, sometimes you'll have something where it's an applicant, you turn down you turn them down, so they sue you. You're in court. Then while they're waiting, they bring another application in, and that one's pending. If you go into executive session to talk about the litigation, you're not supposed to talk about the pending application. Just because sometimes you may want to, like a global settlement, say, well, if we settle the appeal, maybe then we can approve, make a deal with the guy. We'll settle he'll withdraw his application, and he'll withdraw his appeal, we'll approve the application, that sort of thing. But with executive session pending litigation, just what's in court, that's all you can talk about, not other related matters. And with executive session, there's a formality. First you vote to go in, and then you're supposed to vote to invite non-members in. So if you want your attorney in, you want your planner in, you want your CEO in, the record should reflect you invited those guys in. And no minutes are taken during executive session. So the only minutes will be you went in, when you went in, who went in, and then when you came out. So say you were there was an appeal and you were going to settle the appeal, you would need to make that motion outside of executive session. You'd have a formal vote on that. So let's see. does relate with appeals, executive session. On page 8, just a thing on agendas, that agendas must fairly appraise the public of, what you're going to be addressing at the meeting or public hearing. So if you were going to go into executive session to talk about pending litigation, the case name should be on that agenda, not just pending litigation. You should put the name of the appeal or the case. It doesn't have to describe exactly what's going to happen, so it would just be, I think you do it anyway, where you just, the property address, who the applicant is, what they're applying for, special permit, site plan approval, subdivision approval. It doesn't have to be that detailed, just so people know, the property involved and what the application is. On page 9, the posting of minutes. So regular meeting minutes are supposed to be up there within 7 days. Same for special meeting minutes. Thing that catches people, record of votes. That's 48 hours. It's 2 days. You got to get, and that's just simply what you voted on. It's not minutes or anything. It's just the votes taken. So it gets forgotten. And then on page 12, there's a handy little chart on public meetings, for public institutions. Now, page 13, I have a little thing on federal limitations on local governments. I have a separate page on this because when you're dealing with federal law, if you get sued and you go to court and you lose, you can be it's not just your decision gets overturned, is you got to cut a big check to the applicant. Because I don't know if you've heard of a Section 1983 action. There's a federal statute which says if you violate someone's civil rights or constitutional rights and they sue you and they win, they can seek an award for damages, including their attorney's fees. And it's astonishing what attorneys charge when they think that someone else is paying the freight. So if you think your own attorney can be pricey, it'll be triple that if it's a federal action. So Americans with Disabilities Act, you do get to inquire about the disability. You have to be careful, though. I mean, it's a fine line, not being too intrusive, but you do need them to identify, what the disability is. But if someone has a disability, you're supposed to make reasonable accommodations for them. Most of these, ADA will go to the Zoning Board of Appeals because, they want to put a ramp on their house to get a wheelchair in the front door, but that would mean they go in the front yard setback. They would first have to go to you folks. So they don't have to show a hardship. All they have to show is, and then you work together to try to find a nice solution for them. The same thing with the Fair Housing Act is another one you have to watch out for. Again, that's reasonable accommodation, that word. And problem with a lot of these federal laws, they have these nice words. Reasonable accommodation. It's not defined, so we kind of have to make it up as we go along. And it's not a comfortable position to be in. With both of these laws, we do get we just had one with emotional support animals. I don't know if you're getting any of those, where it's not just dogs and cats anymore. It could be, the little pigs. It could be the miniature donkeys. And we had one, it's up in Thomaston actually, where it was 2 miniature donkeys, emotional support animals. And the problem there was because for farm animals or agricultural animals, you needed, a certain amount of acres. I think it was 1 acre per animal. And they had a half acre and they wanted 2 animals. So we sent them to the ZBA for the variance, and that was, what's a reasonable accommodation? Did they get the 1 donkey? Did they, get the 2? And they said, well, if you have the 1, it'll be too nervous. It wants a friend. All these, of course, they already had a couple dogs and chickens and ducks and everything else on there. So those are tricky. What's a reasonable accommodation? And
How did
that turn out?
Well, they got turned down.
Okay.
There's too many animals. What really, I think what hurt their case was they said that a dog is not an emotional support animal. And everyone, of course, we go, what do you mean a dog is not a... They lost right there. But the donkeys, I guess, are noisy.
What becomes the definition of an emotional support animal?
Because emotionals, there are...
Go online.
Is it a therapy animal? Is the one that's a licensed, like trained? You've seen those where you can bring those on the airplane. They truly are a trained animal. That's almost like a seeing eye dog, that kind of thing. Where it's there's no questions. These are the emotional, where it truly is. It's a pet, and it helps you, get through the day. So, but it could be anything. It could be anything. So, but what's reasonable, and that's when the neighbors, what is reasonable? This was a half-acre parcel, and for 2 donkeys, they really should have had 2 acres. So. Right there, and then they added all their other animals on, so it was just too much of a burden on that property. So,
And then the donkeys were violating the noise ordinances, so.
plus if they get out, I guess they chase dogs. I don't know what they are. You were cute. So, but when that comes in, you flip right to the Americans with Disabilities Act if there's a disability. But then that one, because of emotional support animals, there really wasn't a disability, but it was fair housing. Everyone has the right to enjoy their home like everyone else. And these people are like, we can't enjoy our home unless we have these donkeys there. You get to relax at your home. We can't relax unless our donkeys are there. So that was their argument. We were cold-hearted and said, get these things out of there. Also, haven't seen too many of these cases lately, but on page 14, the Religious Land Use and Institutional Personalized Act, again, the key with avoiding trouble under that law is truly treat a church like any other similar use. And a lot of towns get tripped up. It's more cities get tripped up. They'll treat a theater and a meeting place different than a church, which is a big no-no, because what is a church ultimately? It's just another place where people gather. Cities treat them differently because they're worried about their tax base, but the court doesn't want to hear that. They look strictly, and with zoning, again, we deal with land use. We're not worried about the tax rolls per se. A lot of people don't want to hear that. They always say you can't approve this or that because the taxes will go up. We're not supposed to go there. For land use, compatibility of uses, harmonizing uses. So with the religious land use, right, under zoning, they should all be in the same category. Churches, and meeting houses, theaters, all that kind of stuff. And then, again, we have to worry about First Amendment and free speech. That's your sign regulations. Again, all signs, treat them the same. And there it is on page 15, section 1983, civil rights violation. It says that every person who under color of any statute, ordinance, regulation, custom, or usage of any state or territory subjects or causes to be subjected any citizen of the U.S. or other person within the jurisdiction thereof to the deprivation of civil rights and privileges or immunities shall be liable to the party injured in an action at law or their suit in equity or other proper proceedings for redress. And it says a violation of the above can subject you to claims for money damages. We got involved a little bit in Litchfield with the Chabad Lubavitch in Litchfield, and that was like $1 million. Where was the money damage award there for was a historic district permit. They wanted to just remake the front of a historic building, and then in back, which you really couldn't see, put a place for the rabbi and a little pool and stuff like that. So, Historic District Commission turned them down. They didn't like what they proposed. And it goes to court, and the court found that violated the Chabad's, right to assemble. So the Litchfield was liable for damages and attorney's fees. $1 million. It was almost $1 million. So, got to be careful. It kind of impacts the budget. And the insurance didn't pay for it. I still don't quite understand why CIRMA didn't pay. Because apparently attorney's fees are not damages. If they had, I don't know what other damages there would be, but if it's strictly the rabbi test, he wasn't really damaged personally. He wasn't out of pocket any money, well, unless he had to pay his attorney's fees. So somehow the insurance policy for the town did not cover paying the other side's attorney's fees. So check your policy. I don't know. I still don't quite understand it, how that happened.
Generally, punitive damages are not covered by insurance.
Yeah, so be careful. So you think you got it and you don't. So they did provide an attorney for a while, but then once they found out there was just the punitive stuff, they withdrew.
Can I ask a question? Go back to signs.
Yeah.
We call ourselves the sign commission because we get a ton of those. But so the point is making sure that we're not biased according to what they're coming to us for, the purpose,
Right.
right? Because we base it on the regulation, which is size and.
Exactly,
things
where
like
it's
that.
located, all that stuff,
Right.
right? Yeah. So don't look at the content. If you have to, if your decision at all depends on what the sign says, you got to be,
Right.
'cause
Okay.
we don't care what it says. We apparently can still do the temporary sign stuff. So I guess they make that distinction. Temporary signs are all treated the same. So you can't have like the political ones get to go up, but you can't, the yard sale sign can't or something. So I think so temporary, those types of signs. It's not also types of signs, so a bigger sign you could treat differently from a smaller sign, that kind of thing. Because it's not what it says, right? It's just how
Right,
long it's
not
up,
the right.
where it is, how big it is, that kind
What
of thing.
company is doing it or what, yeah,
Illuminated versus not illuminated.
correct.
But could a temporary sign be restricted because it's blocking view in terms of traffic safety?
Well, that's a basis. They always people, that questions is raised. Why do we regulate signs? And it really is for the driver. You don't want distracted driving. So you don't want drivers always. You don't want signs everywhere because you're going to be reading all these signs. Plus, they're blocking view. So it's safety. That's why you do it. So your decisions, so your regulations should reflect that. So that's why you don't want a ton of signs everywhere. That's why you maybe don't want them flashing. You don't want them illuminated. That kind
I'm
of thing.
saying like for the temporary versus permanent, so can the safety trump everything else?
I think with the temporary, if you make them small enough, the safety issue is reduced, right? If it's those little, the little political ones, not the big banner for the school play. I mean, that's temporary, but that
Yeah,
you
but
could.
our regulation, we're not voting on safety, that's not our.
Well, that's the basis. That's where your mind
Right.
should be. It's not content, because people say, why do you
Right.
regulate signs? Well, that's why. It's,
Also to have uniformity, I mean,
but you can treat, but different sign types you can treat
right.
differently. Just don't go to content. Okay. Let's see. I do have some things in here, like how to make a motion, how to change a motion. I mean, I don't know how, the courts can be pretty forgiving about that stuff if it's not properly done. The only thing I've seen sometimes is where something really should have been two motions and you make it one motion. So, something where you're gonna amend the agenda to, hear an application and then in the same motion, it's also to open the hearing. It should be like two, that kind of thing. So just be careful you're voting on one thing. Just like I said, executive session, you don't vote with one motion to go into executive session and invite in people. It's supposed to be two motions to do that. But the courts don't get too fussy about amending, as long as the record's clear what you're voting on. So that's always a good idea. If there's a discussion, there's a motion to approve, there's a discussion, people are thinking of conditions, to pause and then have someone recite and go through and make sure everyone understands what they're voting on. Okay. Here you go. That's that with that. So that's 1 hour on general knowledge. We can keep going on the general stuff and go into the other two books. I would not mind not doing fair housing and unless you want to. So, planning and zoning is this pink one, while ZBA is the yellow one. There's some similarities in here. start with planning and zoning first and just do what's strictly planning and zoning in there. And then we can go on to ZBA. Yes?
I don't have a pink one.
Oh, no, I just gave the one.
Oh, just the one.
Yeah. Yes.
When's our second training session? Because we have, to comment on, maybe not doing fair housing, because we have things we need to learn about affordable housing. Is that something maybe we can go over tonight, if anybody is
We've got a little bit on it if you wanted to, yeah. We could touch on that briefly. I didn't bring a lot because it's,
I mean, that could be the subject of the second training you have. This is only covering, you have 4 hours, it's mandatory this year.
right.
So you're doing 2 this evening, and then you still need to do 2 more. So it could be the subject of your next 2 hours,
Mhm.
which would presumably be in the fall.
Yeah, I could hand out, I brought a couple of things that we wouldn't cover, but you'd have it.
Are you discussing that soon though?
In the box.
Anything like there on that?
This one,
Yeah, so, I mean, we should talk about it if we need it.
100.
Okay.
Okay, that's that guy. And there should be this one. There you go. Let's have Nicole just pass out 2 things on affordable housing, just so you guys can have it. And one is, it's got the pictures of houses on it. It's from the Office of Legislative Research. It's just, they call it an issue brief on the affordable housing land use appeals procedure. Just has those definitions again. What is affordable housing? What's an affordable housing application? And how the court will, reviews your decisions on those types of applications. And the other one is just one section of the Code of Federal Regulations. Basically, it's discriminatory effect, it says. What is it? And that's when zoning lately has been accused of having a discriminatory effect. Well, what does that mean? And Department of Housing and Urban Development and the Justice Department, they do their best to kind of try to describe it, define it, but it's, as you'll see if you look at it, it's a moving target in a way.
Can I ask a general question on
Sure.
fair housing? My quick reading of it says that a certain percentage of total housing in a town has to be affordable.
Right, as defined.
What?
As defined by that act, too. It's not just,
No, right,
yeah.
but so the question I have is, well, what if your town has, say say Woodbridge,
Yeah,
which has virtually no public water, no public sewers, and then there's this requirement of that you have a certain amount of land because you need to put septic systems and wells and all this other jazz in.
right.
But the percentages don't take into account what's the physical geography, what's the physical layout of the town, of any town.
Mm-hmm.
So how does one, therefore, how do you then say, or not, it has to be 10% or 8% or 14, whatever the number is.
Right.
Based on what? Because you may not have available 10%. You may only have available 1%. Again, I don't know the numbers in our town.
Right.
But I do know that some of Woodbridge, as an example, you can't build high
Mhm.
density because you just can't.
Right, you don't have water, you don't have, public
Right,
water
so-
or sewer.
So when you're doing this calculation of 10%,
Mm-hmm.
how on earth can that work?
Right, you may never get there.
It may be physically impossible.
Mhm. Right, so, the one with the houses on there, and on the second page at the very bottom, it says, how can municipalities defend an appeal brought under the Affordable Housing Appeals Act? And you can't defend it. The normal way you would defend an appeal is that, as you say, the application does not meet the requirements and standards in our zoning regulations. With the affordable housing, that goes out the window, and instead, you have to prove, and this is where not the applicant, you guys would have to prove that your decision was necessary to protect substantial public interest in health, safety, or other matters the municipal commission may legally consider, and that these interests clearly outweigh the need for affordable housing and cannot be protected by making reasonable changes to the proposed development. So, there's only been, that I know of, 2 successful defenses to affordable housing. One was where a developer, there was a piece of property undeveloped. I think it was very near or abutted an existing watershed area. And the town for years have been thinking, and the water company have been thinking of adding that parcel to their watershed to provide for more safe drinking water for the town. So when a developer came in and took the property, wanted to build on it, the denial of that application was upheld by the court because that was that met that burden. You know, the interest to have safe and clean drinking water outweighs the need for affordable housing. And then the other one, I forget, was some shoreline community. That was Old Saybrook or Old Lyme. And again, it was this unique shorefront property with wetlands and dramatic, rock landscape and various wildlife there. And the same thing, the town and the state had been thinking maybe turn it into a park or something. Well, developers snuck in there and grabbed it and wanted to put up affordable housing. And they turned them down because they said it was within the public interest, to protect that in its natural state. Our shoreline is largely developed, protecting that undeveloped. So that's the kind of what you would need to show. So for Woodbridge, it was like, well, everyone's on well water here. So we can only have so much. If you had studies to back that up where that development, you would have to, of course, you have to do a lot of heavy lifting. The applicant comes in, I want to build some apartments here. You would then have to come in and say, well, all these people around you, all they have is well water. If you put that in there, it's going to dry up their wells, it could pollute their wells, that kind of thing. Then maybe you would have something to go on. That's why the rule of thumb with once you put in sewers and public water, you open yourself up to loads of development. We're getting that where I am in Farmington. We had to do a moratorium on apartments because we got found out, and man, those applications came in. So we've got hundreds of apartments that are going into Farmington. So our town will be changed. It's, a lot of people say it's not Farmington anymore, or won't be. So that's the only way you can control things in your town. It concerns drinking water, and it's real. It's not made up. Affordable housing's, they've been turned down because the roads are inadequate, and those have been losers. Where the court's always like, well, can't you improve your roads a little bit? Can't that kind of thing? So maybe if a developer came in and said they were going to put in public water and sewers at their cost, that gets around it. But yeah, this is always the one way. The only chance you have to win these things in court is drinking water concerns are big. Because I forget what, I think Torrington Area Health up in Litchfield County, a lot of those towns, I think Torrington Area Health always says 1/2 acre of good land per dwelling, if you will, for your sewage, for your septic, and for your drinking water. That was always their rule of thumb. And that's good land. That's not rock. That's not wetland. That's good soils. So I don't know how Woodbridge is, but a lot of those towns, that's why they have 2 acre zoning, is because with 2 acres, you might have that 1/2 acre of good land. So I don't know if that answers your question, but that's where that goes. When you turn them down, it really is, your zoning regulations kind of get pushed aside. It really is, you're looking at public health and safety. So
I would just like to add, for the benefit of the other commissions from the zoning appeals, as the chair of the housing committee, we are going to be going through our affordable housing plan that's
Yep.
going to have a number of strategies for increasing the number of housing options in Woodbridge. So if anybody would be interested in, I'll make sure that everybody is invited to that, because there are many new technologies and there's other options, and there is the option of expanding the public water and sewer infrastructure. That's not going to change what Woodbridge looks like. In order for us to do the number of affordable housing, we need to comply with state law and
Right.
fair housing.
it's good to keep ahead of it too, because if you get more where you're reacting to it, then you're always a step slow. So, and we're supposed to be doing our affordable housing plans.
Yes.
Yeah. And there are some creative solutions, but and then
Just so you're all aware, the housing committee, not the current one, the one just before, which got reconstituted, did do the required, Board of Selectmen approved it, sent it up to the state, and so that has to get updated in 5 years from when it was adopted, right?
Mhm.
So, that is in there, and that's what the housing committee is going through, is the recommendations that are in that report. So
Okay.
Woodbridge is current with its housing study, and is pursuing it with the housing, committee. Where we are.
Very good. So you're on schedule. And then the other thing I handed you was just, it's 24 CFR 100.500. That's Connecticut federal regulations. We're hearing a lot about the Fair Housing Act and, and your zoning regulations and your plan of development, your affordable housing plan. They're all supposed to kind of, comply with the Fair Housing Act. And of course, what does that mean? And with Justice Department, basically, is you don't want your zoning to have a discriminatory effect. And what that means is they just look at the disparate impact. And that's when sometimes you'll see like a lot of towns in their affordable housing plans, they will go through the makeup of your town and they compare it to the county in terms of people from what groups and that sort of thing. So income levels and race and that sort of thing. So that's what, so even though, with zoning, it's you've adopted those regulations, if they create something that violates the Fair Housing Act, then you're supposed to amend your regulations to try to correct whatever, look at, well, why did this happen? Why are certain people in town, certain people aren't in town? They look always more for, it ties in with the Affordable Housing Act, which is, how much does housing cost? So you look at your regulations, are we making things too expensive to build a home, in your town? So do you need the lot sizes you need? That's a big one, because land is expensive. And sometimes you have, if you don't have public water and you don't have sewer, then sometimes you need the larger lots, that kind of thing. So, but sometimes, what you thought you needed with the emerging technology, sometimes maybe you don't need those big lots anymore. So you just revisit and say, that's always the big one they look for, because land is, when you're looking to buy, that is what's expensive. Plus, making a developer put in all that infrastructure gets, drives up the cost of development. If you can let them build on smaller lots, that kind of thing, maybe it's, the road per person, if you will, that ratio goes down. But you could try to read this and make sense of it, but basically it's just, you have the regulations you have, and if the numbers aren't what, HUD wants or the Fair Housing Act wants, then you're supposed to go back, and that's where most towns start, is just their lot sizes. Okay, all right. Going back to the 8-30G, if you want, the definitions are in there. I don't know if, I'm kind of watching what legislation was proposed this year, but they always make that attempt for the term affordable housing to include market rates. So that way when, if home values take a nosedive in Woodbridge, if you become more affordable, why shouldn't you get credit for that, even though it doesn't meet this technical definition of affordable housing, which is it has to be deed restricted and that sort of thing. And those definitions are in here. And then that 10% number you mentioned, if you ever get to the, that 10%, you can apply to have a moratorium applied to your town from that act if you get to that 10%. And that 10% number is proven pretty hard to meet, because you're always adding more market rate housing, so you're always kind of raising that bar to get to that 10%, how many affordable housing. You can go sooner, yeah, if you're making progress, yeah. Mm-hmm. In Farmington we did, yeah, they got that.
If we were able to get like 60 units of affordable housing, then we could get a moratorium where we could get a 4-year reprieve from a 8-30G application.
At 2% of your housing stock, you can apply for it, and then 10%, you're free. If you ever get to 10%. Okay. So, a little bit on that. We can go back to the these books quickly. Yep. Oh, sorry. Yes.
So just a quick question. So sometimes areas are depressed. So eons ago, Harlem was could buy it for a song.
Mm-hmm.
And now there's a bunch of gentrification, so things are now worth a lot more money.
Right.
So what happens in a community where you met all the requirements of affordable housing,
Mm-hmm.
but for some unknown reason it becomes the most popular place on earth to go to,
Mm-hmm.
and now all the houses are more expensive?
Right.
Are you now out of compliance, even though you were in compliance?
Well, with the definitions here, it's that what is defined as affordable housing. That's why they have like the deed restrictions in there. So those, your affordable unit should stay affordable for a certain amount of time. So that you should be, in the short term, protected from market fluctuations. Does anyone have to go?
Well, that was only
This time of night, yeah.
Oh, it's you're out?
All volunteer firefighters.
Right. It does happen though. Okay. Enough of that? Okay. So I thought we'd do the pink one, the planning and zoning, just touch on a few things in there. That just planning and zoning, ZBA, you can just hang in there. And,
I don't have a pink one.
no, because you're ZBA. You just got a yellow one.
Oh, okay, good.
If you join the other commission,
Just gonna close my eyes. No, that's all right.
So fight fires.
so for planning and zoning commissions, page 3, I just put down your powers, duties, you know, you hear your site plan and special permit applications and decide applications to amend your regulations. And of course, you can do pre-application reviews. For both the ZBA and Planning and Zoning Commission, the role of an alternate, I don't know if you know the rule, is that an alternate can participate during a public hearing. They can sit at the table, ask questions, that sort of thing. When the public hearing is closed and you go into deliberations, you're going to vote on that application, alternates are no longer allowed to participate. So,
But you can't vote.
only if seated. If they're seated, they can vote. If they're not needed,
Oh, right,
Yeah.
no, if they're seated.
if they're seated, they can vote, yeah.
And but can they participate in the discussion?
If they're seated,
Ah,
yep.
got it.
So if they're not seated, they're not needed,
Yeah, yeah, yeah.
yep. And then just for, again, for both the ZBA and PZC, ex officio members, that's usually your first selectman, is of course an ex officio member, and that person, they can't vote, but interestingly enough, he or she can sit and make a motion. So, can't vote, though. And we covered public meetings and public hearings. Okay. On page 11, again, this applies, just make sure you do the proper notices, which includes, you do the notice of the hearing, it's notice to your adjoining towns if the land involved is within 500 feet of a town border. Supposed to notify your regional planning agency. And also, I don't know if your regulations have required notice by mail, but that must be complied with. You can't waive that. If your regulations require notice by mail, then that's usually to abutters or people within a certain radius of the land. So, and again,
Both your commissions don't have it in your regulations. It's done as a courtesy.
Okay.
So it's a courtesy notice, except for wetlands where they mandate that the applicant do that notice. And what they have is they have the applicant submit a certificate of mailing to prove that they mailed something to
Mhm.
all the occurred.
Right.
And that's submitted as part of the application file.
right. And that's usually should be your first item of business when you open the hearing, just to make sure the notices were done, because that way you don't waste everyone's time if for some reason the newspaper didn't get it done as needed, which happens more and more these days. Sure.
So a lot of paragraphs here reference general statutes.
Right.
Which dictates what's allowed.
Mm-hmm.
Some of them don't. So the ones that don't reference the statute, what is their power? What is the power to what their come from? It's not referencing the general statute.
Well, like I'd say, we'll go down page 11, like letter F, failure to publish notice in accordance with regulations. That's a court-imposed penalty. Again, you'll notice by mail, that's by your regulations, so you don't have it, so you don't have to do it. But then abutting towns, right, you'll see that's in there. I also have in the back of both books some applicable copies of the statutes too, if you wanted to actually read through them.
So is everything in this book either supported by statute or law?
Yes. Yep. Try to study just a case. Of course, it's usually multiple cases, but right, that's where that's what I cited you, because your authority comes from, of course, the state of Connecticut.
I
So
remember it from,
we always ask, if you want to do something, you look for that power, that authority in the general statutes. And then your regulations also draw their authority from the general statutes, so. Or court decisions. Okay. Now, on page 13 from the planning and zoning, finality of a decision, of course, this applies to the zoning board of appeals. Your decision on an application is not final until it is published. So you can, if you vote on an application, and then it's really almost, on the rare occasions, you might find the need to re-vote on something. Maybe you thought, there was a vote and maybe an alternate wasn't properly seated, something like that. So you want to vote again. If it's not been published in the newspaper, you can do that to cure a technical problem.
What if it's a substantive problem? What if you just change your mind before it's published? Is there an opportunity to
Only
revisit?
if, yes, something is substantial evidence, like the one thing I said was, like a staff report, your own consultant or something, if for some reason, you voted before you had your consultants, maybe you hired a planner to look something over, maybe you hired a traffic consultant to look something over, and for some reason you forgot about that, whatever, and you took a vote on that application, then that report comes in after the fact. And it's a significant piece of evidence. It could changes your mind on it. You could revote. So right, you could have a revote.
But only up until such time as notice is published of the initial vote.
Right, once it's published in the paper, because that's when the appeal period starts to run, if someone wants to go to court. So that's when it's final.
So they would have to schedule a special meeting, so we'd have to
Yeah.
email everybody, find your availability, schedule a special meeting, and then do that.
Or if you had a vote and you found out someone had missed one of the public hearing nights, they shouldn't have voted. That kind of thing, clear up. But yours is a difficult one. I don't want to stray too far down that there. It would be a unique situation where evidence came in, because nothing's supposed to come in after the public hearing. And one thing I can always think of is, well, if it's a staff report, your consultant's report, and for some reason you didn't wait for it, you forgot about it or something, then you could do a revote. But it's got to be something substantial, not some minor thing. I've often seen it. You're taking care of a technical infirmity. Like I said, an alternate who wasn't seated, participated or voted, something like that. So you want to clean that up.
so the notice of our approvals are published within
They need
48
within 15 days. They need to be
15
published.
days in the paper?
Yes. Substantial circulation in the community. Yeah.
Currently, it's only in the paper.
Right, they haven't changed that.
It could have been on the website. So now we're spending more money on printing the paper than anybody else.
That might be gone. I don't know.
I think they're working on it.
Yeah, they're working on it. Who knows what's going to happen there?
So if we receive substantial evidence after our vote, the night of the meeting,
Mhm.
and it's not published, and it's day 12, we could technically
Have a
revote.
special meeting, right?
Special
There's enough
meeting
time
and
to put the
revote.
notice up, that, the 24-hour notice, get together and do a new vote.
Well, thank
But I
you.
don't
I wasn't
normally
aware
wait
of
that
that.
long to publish, because I don't want to miss that publication.
Amen. Exactly.
Well, so then we need to know that. We need to know how many days you're taking to publish so that we're aware of it,
I
right?
do it as soon as I can,
Mhm.
just to get it done.
Yeah. Plus it cuts down the appeal period.
Yeah.
Should be rarely done, though, where you do a revote.
Correct.
But that also means at have seen where at that meeting, there's deliberation, there's a vote, like I said, there's a vote taken, but maybe you're not sure what you voted on, there's a disagreement after the fact, what did we vote on? Then, redo it. It's not final till it's published, so. If for some reason you feel that what you did was, it wasn't clear what you voted on, or someone who voted, maybe they shouldn't have voted, that's, you can tidy it up right there. Let's see. For planning and zoning, page 16, special permits. The special permit application, again, that's a public hearing. Renewal and revocation of a special permit, you can include as a condition of approval that, if those conditions are violated, the special permit can be revoked as like a penalty. But if you're going to do that, you need to hold a public hearing to give the special permit holder a right to be heard and defend his or her permit. The other thing we've seen lately is, we used to, special permits, they ran with the land once you approved it, it's good forever, but the courts have now revisited that. And, with a special permit, the courts have said, often with a special permit, someone needs to build something to get the special permit use going. That you could put a time limit on. So if it's, if someone's putting in like a little retail store or something like that, you could put in, say, you're approved for that special permit use, but you need to have it completed within so many years. And the reason behind that is the courts recognize circumstances will change, where today you approve that special permit, 5 years from now, that neighborhood could change, and with nothing being built, those property owners are coming and they have no idea something was approved there. So it's not really fair to them to have this thing looming out there, So you can put a time limit in that, when that use has to be put into place. A little bit on zone changes on page 17. Thing with zone changes, you often will hear people who are opposed to your zone changes, it's spot zoning. And spot zoning is basically like what it sounds like. It applies to like a single parcel. So whenever you do approval of a zone change, it's you do need to refer to your plan of conservation and development. So while the statutes look at that plan of conservation of development as being merely advisory to what you do, the courts take it very seriously. So if you're going to amend your regulations, always cite to your POCD and see how your change fits in and furthers the goals of your POCD. And then when you're approving a zone change, sometimes someone will submit what's called a protest petition. They're against it. If someone does submit a valid petition, it's got to be, let's see what it says here, signed by 20% or more of the area of the lots included in or within 500 feet of the proposed change. If that petition comes in, it represents 20% of the land involved or within 500 feet, you need a 2/3 vote of the commission to approve that zone change. So that's a good way to kind of kill the application. Okay. Let's see. On page 19, we get into enforcement a little bit. Of course, the Planning and Zoning Commission has the authority to appoint its zoning enforcement officer to enforce the regulations. And there's certain penalties, again, provided by statute 8-12 and then 8-12A. And just be aware those penalties are imposed by a court. So you have to go to court to get the 8-12 penalties, and that's the, the $100 a day. If it's willful, it's $250 a day. And that's at the discretion of the court. So you can win at court, and the judge doesn't have to award you the fees. Often what I've seen done is the judge will tell the violator, if you're back here again, then you're going to get the money penalties. So you get that one chance, even though the commission, the town, you spent $5,000, whatever, $10,000 to enforce your regulations. you don't get that money back through fines or anything. 8-12A, I don't know if you have the citation procedure. That's where the ZEO can issue basically a ticket for a zoning violation.
We do have that, and we have a citation hearing officer.
Yep.
So that's all set forth in the town ordinance.
So the citation violations don't go to ZBA, they go to the hearing officer. Okay. And then, in terms of enforcing your regulations, the passage of time does not allow a violation to escape enforcement, except for a building that violates setback violations. If that building's there, I think it's for 3 years, it becomes legally non-conforming, so you've got that window of time, so. That's not really fair to your ZEO sometimes, because if it's a backyard, violation, how are you gonna spot that unless a neighbor turns the guy in? Let's see. On page 21, talk a little bit about plans of development. And of course, you're supposed to look at your plan of conservation and development every 10 years. The statute also does allow for anyone to file, I guess, an application with the Planning and Zoning Commission to amend the POCD. I don't know if that's ever happened, but it's in there, so you're not taken off guard. Someone could file something with you. They want to change something in your POCD.
So in your case, that did happen where they appealed or submitted an application and they added farming concerns into the POCD. So it has been done. And they can also
Mm-hmm. And your plan needs to comply with the state conservation plan of development too, so. And that compliance, that's how you get some of your discretionary funding. If your plan doesn't mesh with the state's plan, it can jeopardize discretionary funding from the state of Connecticut, so. That's usually handled when you do your plan, you just send it up. I think it's to the Office of Policy and Management, and they'll check it out and let you know if they see a conflict. So on page 23, there's a little bit on subdivisions and re-subdivisions, which you don't see too many of those anymore. But what's a subdivision? What's a re-subdivision? It's you go strictly by the state statute. We're getting I've seen quite a few things where it's people doing creative land development where they're moving boundary lines between lots, and in the old days you would call it a subdivision, where basically the reconfiguration is so significant the lots look nothing like they used to look, where they, maybe it was one large lot with 3 small lots and for a total of 4, and then someone buys all 4 and they move those lot lines all over the place. But the courts have said that with the subdivision, you go strictly by that state definition, which is 8-2026, I believe, means a division of a tract of land into 3 or more parcels or lots, whether for future or immediate sale or building development after the adoption of subdivision regulations. So it really is, you have to have 3 or more lots created, and they're going to be offered for sale. So if that question ever gets before you, usually it goes to your ZEO and they'll make a decision on it, but a lot of them will bring it to you. And the courts have also said that really what is a subdivision, what's not a subdivision, is a function of a planning commission. Your ZEO is only for zoning. So subdivision questions really should be brought to you guys, to the commission. And you make that decision. A lot of towns, the ZEO or the planning, the staff will do it, but the courts have kind of weighed in on that and said it really is a decision for the planning commission to make.
And there are a couple of exceptions to a subdivision, so conservation,
Right.
farming.
Agricultural purposes. But this one comes under boundary line adjustments, and that
Yes.
can be some crazy stuff, where in the old days, if it was significant changes, we would say, no, that's
That's a
subdivision, but not anymore. You gotta look for lot creation, so. Of course, staff can always advise someone where they think that.
Yeah,
Okay.
or I say I'm not the legal people, this is mine.
Okay. And did you know about waiver of subdivision regulations? That does not go to the ZBA, because the ZBA waives zoning regulations. So, Planning and Zoning Commission, you can waive subdivision regulations. Takes a 3/4 vote to approve such a waiver, and the standard is the same as for a variance. It's that hardship requirement. So, if someone can't satisfy for some reason a part of one of the sections of your subdivision regulations, they do need to show the hardship to them. It can't just be they'll make less money. The most typical waiver I think you find is often, do you have how long a road can be, how long a cul-de-sac can be? That's often the one they try to waive. It's, yeah, most towns put a limit how long a dead-end street can be. Okay. All right. Let's see. Do you have any other questions on subdivisions? But with subdivision applications, do be mindful again. If you don't make a decision within that 65 days, it can be automatically approved. And also, with the subdivision application, you do need to go through. And with subdivision, it's often very specific requirements, specific standards you're trying to meet. So if you're going to deny it, make sure you cite to that section they didn't satisfy. So you're not supposed to deny a subdivision application based on general concerns. It really should be specific standards in your regulations. Now, municipal improvements under 8-24, those get referred to you often by your Board of Selectmen. Again, it's a strict statutory definition of what type of municipal improvement, comes before you for your recommendation. And that's all you're doing. You're not really approving it. You're recommending whether it's, a good idea for the town to, either they're selling town property, they're going to use it town property for something. And what's nice about that decision when you make an 8-24 referral is it can't be appealed to court because it's not a final decision. Okay. Let's see. Ooh, page 29, non-conforming uses. These get to ZBAs more often than planning and zoning. And the thing with non-conforming uses, that's just a use that was legal and it predates the adoption zoning. Big question you always get is a non-conforming use expanding? Non-conforming uses aren't supposed to expand. If anything, we hope they get smaller and go away. So, however, the court says a non-conforming use can intensify. That's often like a business. A business should be allowed to grow. So, with intensification, that's often seen as more of the same. So if it's a non-conforming restaurant. And they just want to add more tables, or it's a non-conforming gas station, they want to add another gasoline pump or something like that. That's intensification. Expansion is often, it's occupying more space. It's expanding. If it's a building, it's expanding further into a setback or something, or it's expanding onto another piece of property. That's
what
not
we
permitted.
get all the time.
What's that?
We get that all the time. I mean, you cannot expand the footprint of the
What you can do is they can horse trade. If they expand in one direction, if they offset that with a reduction someplace else, you can allow, that can be okay. The tough ones are sometimes when they're building up, they're staying within the footprint, but they're building up, and that's, the courts have said that your zoning regulations control there. You can define whether or not building up is an expansion or an intensification. So,
But you're talking about business.
what's that?
You're talking about commercial business, right?
Well, this is residential in the case of the building getting bigger, yeah. So shoreline communities, you often see it where someone's got the beachfront property and they want to add a second floor, and the guy across the street's a little bit upset because now his view is blocked. So a lot of those communities say, no, you can't build up. But in other towns, it's, if it's Newington or something, what do they care if you build up? So as long as you're within the footprint, to them, it's not an expansion, it's intensification. So your regulations can define how big a building can expand. Just like if a building contains a non-conforming use, that building should not be allowed to expand, even if it's within setbacks. Because by expanding, that use is expanding. It's occupying more space. There's a case of like an ice cream factory where the guy wanted to put a refrigerated trailer against the building and then store ice cream in the trailer. And of course, that's an expansion of that non-conforming business. You're occupying more physical space. But the courts have said your regulations can allow, some towns allow up to a 25% expansion in space. So, again, with non-conforming uses, your regulations can define what's an expansion, what's an allowable expansion or intensification, if I'm making any sense. So you can take control is what I'm saying. If you're getting a lot of I don't know what you get here, but like the shoreline communities, it's always those teeny tiny lots, or if there's a lake in town, those teeny tiny lots are always trying to make those buildings a little bigger. You could tailor a zoning regulation to allow for some expansion if you wanted to. You don't have to.
A front porch off a non-conforming house.
Right, adding a porch, garage, maybe,
Garage.
right?
Right? I mean, we get that all the time.
So if you get a lot of those coming in, you might say, you know what, maybe that's what they want. It's what the people want. Let's see if we can accommodate them. But other places it might be like, no, it's a beautiful view of that lake. We don't want those lakefront guys getting any bigger because they'll block our view. So you're very strict.
Well, another typical what we get for ZBA is a house that was built in 1832. And it's 3 feet from the road,
Yeah.
and the entire house is in the setback, but they want to put a porch on the back of the house,
Mm-hmm.
which nobody can see.
Right. So who cares?
Well, but then that's expanding a non.
It is though. Yep.
So, but then.
But do you allow it? Do you then say in your well, in that case, we won't see it that way.
Not to put in regulation, but.
Yeah, you can't.
But we can say that. But, it becomes difficult, or even if what they want to build in the back of the house, if it was 1 inch separated from the house,
Mm-hmm.
it would be conforming,
Right.
because it's in the setback.
Yes.
But if it touched the house, it's not conforming.
Mm-hmm. Right. I know. Ooh. You know what we'll do for 10 minutes or 15 minutes? We'll go to the yellow book and do a little hardship stuff, variance stuff. I'm not going to cover the crazy changes they want to do it hasn't passed yet. We'll stick with the old rule, which is unusual hardship. To get a variance, where did I talk about? The yellow book for the ZBA people, page 17. Variances. And if you've been on the ZBA for a while, you remember for quite some time you did have some discretion what was a hardship, when you could grant a variance, because the state, the language in 8-7, was always very strict, which was basically the zoning regulations render that property useless. If you could use it for any reasonable purpose, you don't get the variance. So if you got that teeny tiny house and it's got 1 bathroom and 1 bedroom and you cannot add on to it because it's a reasonable use. But that rule had been kind of relaxed, where if someone wanted a garage, having a garage in New England, that's, it's a hardship not to have one, right? So you can get them to have the garage. So it was, but the courts a couple years ago brought us back, very strict. If there's any reasonable use for that property, you can turn down that variance request. So if there's already a house on it, and the guy wants to add on to it, too bad. It's already being used. It's already got a use.
I know, but when we did it in the past and now we're not doing it now, that's kind of.
The courts just, I know, and they themselves recognize, I remember that for the name of the case, but they cited, and the one I always remember was where it was, a woman, she had lived in this house for years and she was getting older, but the house did not have a bathroom on the first floor. So she'd moved her bedroom down there, but no bathroom. She wanted to add a bathroom, and the only place she could do it because of where her well was and her septic and that thing was within the side yard. And the court says, well, that's a unique hardship for her. Let her have her bathroom. And the Supreme Court of our state explicitly overruled that case. That was wrong. She could always move, I suppose, or take her chances going up and down the stairs. I don't know. But, right, so it got very strict. I think that's why before the state legislature there was a bill offered to soften the hardship requirements. So you guys would have, because the way it's written, it's almost, you really can almost never grant a
Correct,
variance.
because there's
Yeah.
a hardship in the land, period.
Period. So it's got to be, and it would be like that one piece in property.
And then the second thing is that you can't be a self-imposed hardship.
Right,
So merely coming before the ZBA, it's self-imposed.
right. Unless,
Switching over, see, you
right.
got it.
Exactly. So it's,
Well, I mean, that's what the regulation was.
yep, that's how strict it is. Yeah. So it really would be that very unique situation where the planning and zoning adopted some amendment that affected this one guy in a strange way that, you know, caused him an unusual hardship. And then you could alleviate it, make that exception to that new amendment. But otherwise, right, you come to town, buy a piece of property, too bad for you. Yeah. So we'll see what happens. I think the proposed bill creates a lot more problems. I think it goes too much the other way because you don't want the ZBA granting variances all the time because then you could little by little just undo the zoning regulations. So it's too bad they just didn't go back to how the courts used to interpret it and try to codify what we had been doing for ages because that seemed to work. So, but who listens? But you're right, when determining the hardship, though, focus on the property, not so much the person, because personal problems, personal hardships, we don't care about. It's how is that, what's wrong with that land? Why can't you use that land? And the fact that a zoning permit was issued in error, that does not constitute a valid hardship. So, right, it's really the land, as I say, it's peculiar topography. It has to be unique. If every lot on that street has that weird topography with a lot of bedrock sticking out and wetlands everywhere, well, it's too bad. They're all the same. And you brought up self-inflicted hardship. That's where you kind of create your own problem. Again, financial hardship, that's personal, we don't care about. Except with financial, if they can show you that the property is worthless without that variance, which is hard to, it's a tough one to meet. If you're gonna, and if you do approve a variance, you can attach conditions, because as you know, to approve a variance, it's the two tests, two prongs, it's unusual hardship, and it will not adversely affect the comprehensive plan. So that's where you take care of the neighbor. So you get the variance, but maybe he's gonna do some bushes to screen his neighbor from the porch, which is too close to him, or whatever happened. And once a variance is approved, it does run with the land, so it's forever. And I do address on page 21 of the yellow book, I do bring up again reasonable accommodation. That is a separate, there's, well, I guess two times you don't factor in unusual hardship. One is where the variance will reduce a nonconformity. The classic one is they're changing it from one unpermitted use to another less offensive permitted use. In the case there, the classic one was the unpermitted use was like a lead foundry, and the guy instead wanted to open up an auto repair, which was not permitted either, but they're happy to get rid of the foundry and have the auto repair. That's okay. You're going less non-conforming, making it more conforming. And the other one is, of course, reasonable accommodation, where someone comes in, they need a ramp to get into their house. Or I suppose, would it be like that older woman who needed to move a bathroom downstairs because, you know, she couldn't use the stairs? Maybe she comes in under ADA and gets her variance that way.
But there's a reasonable accommodation that you just, like a ramp,
Mm-hmm.
and when the person leaves, does the ramp stay?
I know, because technically a variance runs forever.
Yeah, well, if it's the hardship in the land, that makes
sense,
sense.
but it's hardship in the person.
If the hardship's in the person,
Right.
it's like, it doesn't make sense.
I always thought it goes away, 'cause it's a personal variance, it's kind of it's its own thing. So you could put that condition in there and see what, but I think the expectation will be, though, when you approve it, it could end up staying, so conditions of approval, you would make it so it looks, it looks nice in the neighbor, it doesn't affect the neighbor's property, so maybe they screen it, put some landscaping in front of it, that kind of thing. Maybe they want the ramp to come straight out, is there a way you could design it where it kind of, that sort of thing. Explore those options, because it could end up staying. You could argue, it goes when the person goes, but I don't know.
A reasonable accommodation, when you talked about that other example, when the woman or whoever needed a bathroom downstairs.
Right.
And expanded the nonconformity, why wouldn't that fall under,
I think it would,
right?
right? If she came in and said, I can't get up the stairs anymore. That's a reasonable
What are
accommodation.
we, mean, terrible people? I mean,
You gotta, you're moving. That's how I always saw those rules, kind of, to kick someone out of their house. That's your role, is how can someone stay, but that's what I thought so
But
too.
it would fall under that.
I think so, right. Now, if it's so their mother-in-law can move in.
You can be bought.
She has-
Nope, I know, right? Do you a favor. And recording requirements for variances and also special exceptions, those are supposed to get recorded on the land records of the town in order, they're not effective until they're recorded. So, some towns put a little reminder in for the person, when they get their letter of approval, please record this, on the land records. 'Cause a lot of people don't know if they're self-represented, they're just coming in, they're not gonna record it. And that way, going down the road, when we're no longer here and someone else can just look that up easily, what's allowed on that property, why do they get to do what they do and the neighbor doesn't? Well, they have a variance.
So we're user friendly here, and on those things, I ask for the check to do the recording, and we do the recording and
Ah, that
then
is
send the
user-friendly.
original to them, because it's saving that extra, carbon footprint thing of them coming back here or whatever, and then, so they submit 2 checks, your application fees, and then they submit a separate check for the town clerk to record.
Very nice. One last thing applies to everyone. Interveners. I don't know if you ever get those. Environmental interveners. And it's under 22A-19A. It allows anyone, so it could be someone from anywhere, out of town, out of state, whatever, they can come in and into your hearing or your meeting and give you a notice of intervention. And it's a simple notice, just who they are. And it should say they're coming in intervening under, they should cite the state statute, so you know exactly why they're intervening. And when they do intervene, you treat that person the same as you treat the applicant. They're like another party, if you will. And they get to raise environmental issues. So if there's someone's looking for a variance or subdivision approval, something like that, even though you deal with zoning, they get to bring in environmental issues. And the applicant often gets upset because maybe they've already been to the Wetlands Commission and gotten approval. And it's like, yep, we got to do this all over again. So bring all your wetlands stuff here and we'll look at it. So, but it's just for environmental issues. And it's basically how the application, if approved, would have a negative impact on, the air, the water, the land, the animals, that sort of thing. So I have a picture of the Lorax in there for a reason, because it's basically the same thing. So, and they have the right to appeal your decision on their own. And when you make a motion, if you're going to approve that application, you actually make 2 approvals. One approval is, yes, there's a hardship. Yes, it meets all our zoning criteria. But the second motion will be under 22A19, by approving this application, it will not have a negative, will not, a double negative? It will not have any impact, adverse impact on, the public trust in the water, in the air, and that sort of thing. So it's 2 motions on that. You have to have a separate one for the interveners application. And that's when you could redo it, right? If you make your decision, you forget to do it, and your town attorney or someone says, oh my gosh, you guys got to go back and do another vote. You could, if it's not published, you can go back and correct that. All right. How about that. You guys got 2 hours done. You're halfway done.
Thank you.
Do you offer CLE credit?
See, 2 credits, so.
Do you?
What's that?
Do you offer CLE credits?
No, I always get asked to do that.
Oh.
Yeah, because we do. It's also when we do and we have like an annual meeting at the AquaTurf, so you get food and you get this. And yeah, people, sometimes the planners, people say, "Can you do get the CLE credit?" And it's a bit of a headache, but I always wonder.
Yeah.
Now that we have to do this, maybe it's worth it. You know.
Yeah.
The other thing we might do, is we might do some Zoom. I don't know if you guys like in person versus Zoom educational sessions. I like getting out. Some people just like. I just feel when I'm doing, I feel like I'm zooming and people are at home. You kind of tell people are kind of like not really paying attention.
Happens to work all the time.
Yeah. Or they let the cat jump up on the keyboard.
Thank you.
You're welcome. Thanks for having us out.
Thank you.
Pleasure.